As we rely increasingly on the electronic storage and exchange of information, protecting that information becomes very important. That brings up two key concepts: cybersecurity and data privacy. Some people use these terms almost interchangeably, but they aren't the same, although some security measures overlap. Cybersecurity focuses on the hardware and software used to store and manipulate data, and the procedures for using such systems. Data privacy focuses on the rights of the individuals or companies that generate that data to know who collects their information and how it is used. Regulations and guidelines for protecting clients' information and privacy aren't new, but recently, regulations specifically for insurance licensees have increased significantly. On March 1, 2017, the state of New York implemented 23 NY CRR 500 cybersecurity requirements for financial services companies. It requires all individuals and entities operating under a license, registration, charter, certificate, permit, accreditation, or similar authorization under banking law, the insurance law, or the financial services law to have and maintain a cybersecurity program. Subsequently, the National Association of Insurance Commissioners followed New York's lead by passing its own model law in October 2017. To date, 8 states have adopted the model law. A number of other states also have similar cybersecurity laws under consideration. Each state's regulation varies in its particulars, of course, but they have certain common key requirements: risk assessment, protection of data integrity, application security, informed oversight of the information security program, employee training and monitoring, oversight of third-party service providers, incident response and notification plan. Licensees must document their cybersecurity programs with written policies and then periodically certify compliance with state regulators. In some states, exemptions are available for some individual or business entities, but for entities in particular, these are often limited exemptions. You may still need to comply with some requirements. The groundbreaking legislation for data privacy was the European Union's General Data Protection Regulation, GDPR, adopted in 2016. This law greatly expanded privacy rights for EU citizens. In 2018, California passed the California Consumer Privacy Act. This law gives California consumers the right to know what personal information is collected, used, shared, or sold, both as to the categories and specific pieces of personal information. The right to delete personal information held by businesses, and by extension, a business's service provider. The right to opt out of sale of personal information. Children under 16 must provide opt-in consent, with a parent or guardian consenting for children under 13. The right to non-discrimination in terms of price or services when a consumer exercises their privacy right under CCPA. On May 29, 2019, Nevada expanded its online privacy law to include CCPA-style provisions. A number of other states are considering similar legislation. Each state's regulation varies in its particulars, of course, but they have certain common key requirements. Businesses must provide notice to consumers at or before data collection, create procedures to respond to consumers' requests to opt out, know, and delete. This includes providing a Do Not Sell My Info link on websites and mobile apps. Respond to consumers' requests to opt out, know, and delete within specific timeframes. Verify the identity of consumers who make requests to opt out, know, and delete. Disclose financial incentives offered in exchange for the retention and sale of a consumer's personal information, including how the value of that information is calculated. Maintain records of requests and how they were addressed for a specific time frame. Businesses handling very large volumes of personal information may need to comply with additional record-keeping and training requirements. Due to the extremely specific nature of the information required to affirm compliance with state cybersecurity and data privacy regulations, ILSA cannot make these affirmations on your behalf. Still, we understand the importance of cybersecurity and data privacy. That's why we collaborate with Renaissance Systems Inc., RSI, to offer you a full range of cybersecurity solutions. RSI's best-in-class automated cyber risk management tools and professional services help you quickly identify your weaknesses across employees, processes, technology, and vendors. Once you know where your risks are, their experts help you develop a remediation plan to address these vulnerabilities. They then provide the tools and resources you need to keep your entire company cyber-aware and compliant. These tools and resources address the regulations that apply to your business. New York Cybersecurity Requirements for Financial Services Companies, 23 NY CRR 500, NAIC Insurance Data Security Model Law, NAIC 668, California Consumer Privacy Act, CCPA, General Data Protection Regulation, GDPR, Health Insurance Portability and Accountability Act of 1996. HIPAA. By going through ILSA to get RSI services, you receive our discounted monthly rate. Also, there's no contract required. You get the help you need for as long as you need it. Contact ILSA today to learn more.